Hello students, as you know that we have started this chapter number 2 of CPC and we are doing definitions. Out of definitions we have completely completed the definition of decree. So if anyone has left this lecture, you can watch the previous one where I have elaborately discussed about decree. Okay. In today's lecture we'll be doing some other definitions. Let's just start. So first of all, see, first definition is of judge. Where this definition is defined, it is defined under section 2, clause 8. And who is a judge? Judge is always a person who will be the presiding officer of a civil court. A person who is the presiding officer of a civil court, we will say that he is the judge as per civil procedure code. Okay, now what is the meaning of judgment and where it is defined? The judgment which is preceded by decree, where it is defined, it is defined in section 2 and clause 9. What is the meaning of judgment? See, judgment is always a statement, and that statement is given by a judge who is the presiding officer of the civil court. What kind of statement will he give? He will give the statement about the grounds of a decree or an order. So that will be the judgment, a statement which is given by the judge of the grounds of decree or order. There is some reasoning why the decree or order has been prepared. So it is a statement regarding that. What are the essentials of the judgment? See, there should be a statement for the grounds of the decision. Why has he taken that decision? The judge should apply his mind while deciding any case, right? The concise statement of the case. Concise statement means the case of the plaintiff as well as the defendant, both should be there in the judgment. The point for determination, what the court has to decide on, right? And the decision thereon. What are the points he is deciding in that case, right? And what has he decided on those points? These should be there in the judgment. And the most important, the reasons for such decision. If there are no reasons given by the presiding officer of a civil court in the judgment, then it will not be a judgment, right? Because without this we can't say that the judge has applied his mind while deciding the case, because the judge, he cannot decide the case. He cannot just say that your suit has been decreed or your suit has been dismissed. He should properly apply his mind, and for that I will be telling you this case which is of Supreme Court. Before that, see, the judgment of a court of small causes. Even the court of small causes, while they are giving the judgment, what should it contain? It doesn't have the 5 elements which should be there in the judgment of a civil court, but what does it contain? It contains the point for determination and what are the decisions their own. That should be there in the judgment of a court of small causes, right? Now the case Balraj Taneja versus Sunil Madan. This is the case which has been decided by Supreme Court. The year was 1999. See, in this case, the apex court has said that judge, see, cannot merely say the suit is decreed or the suit is dismissed. The whole process of reasoning, the reason should be there in the case. Okay, one way or the other. Even the small causes court's judgment must be intelligible and must show that the judge has applied his mind, right? This is very important. Okay, the judgment need not, however, be a decision. See, it is not necessary that the court has framed the issues in which the judge is going to decide the case on, but it is not necessary that he has sorted all the issues in the case. Even an order which has decided the preliminary issue in a case, that is also a judgment. For example, the judge has decided constitutional validity of a statute. That is also a judgment, right? Now the order passed by the Central Administrative Tribunal, you cannot say that that is a judgment, right? Even if it has been prescribed as such. Means even if that judgment contains all these essentials, but we cannot say that the order passed by cat is a judgment, right? Similarly, the meaning of the term judgment under the latter's patent, this is wider than the definitions of the judgment given under CPC. Students, this para, this is very important for you from the preliminary point of your examination as well as your interview point of point of view, right? You should know the order passed by the cat is not a judgment, and the judgment under the latter's patent act, it is wider than the judgment which has been given under the CPC, right? Next definition, the distinction between judgment and decree. See, the last lecture was totally about the decree, and today we are doing about the I have already told you about the distinction between judgment and decree in the previous lecture, but let's just revise over here. See, what is the judgment? As we have done, that it is a statement which is given by a judge of the grounds of decree and order. And what is the decree? See, there is no such statement in a decree by a judge. Okay, it is only necessary in the judgment, right? Here is that it is not the formal expression of the order in the judgment. However, in decree there should be the formal expression of the adjudication of the court. And the last para of the judgment, what does it say? It should state what the relief judge has granted to the party, and it was initially not there in the CPC. It was inserted by the Amendment Act of 1976 under Order 20, Rule 6A. By this amendment, court has to specifically mention in the last para of the judgment that what relief has been granted to what party, right? There is nothing of this sort in the decree. Judgment is always a stage which is prior to the decree or an order, because it is a statement of the grounds of decree and order, and decree, it follows judgment, right? And if in any case there is a discrepancy between the judgment and the decree, the judgment will prevail. Why it will prevail? Because it contains everything. It contains the concise statement of the case, it contains the point for determination, it contains the decision thereon, it contains the reasons, what are the reasons by which on which the judge has decided this case this way, right? So always judgment will prevail because it is the elaboration of the case of the parties. Next, order, where it has been defined, it is defined under section 2 clause 14. What is the meaning of this? See, order and decree, all they are always the formal expression of what? Of the decision of a civil court. But what is the difference between order and decree? Order is what? Which is not a decree. This is the only difference. Though we will do some other differences between order and decree, but majorly to which you will say that this is order which is not a decree, and it should be the formal expression of the decision of the civil court. See, adjudication of a court which is not a decree is an order, right? Now, what are the similarities between order and decree? The adjudication of a court, it may either it will be a decree or it will be a order, but it cannot be both. Either court will pass. What is the difference is that in any case there will be only one decree, except certain other suits where two decrees, preliminary and final, are passed. There is only one decree. And order, in any suit there can be multiple orders, right? So the adjudication will either be the decree or the order, but it cannot be both, right? There are some common elements. What are those? Both relates to the matter in controversy, of course. Both are the decisions, the adjudication which are given by the court. Adjudication of a court of law, right? And both of these are the formal expression of the decision. The court is expressing formally what the court has decided in the order and the decree. Next is, what is the distinction between order and decree? This is very important, students. You should do it properly. Okay, the first difference is where the decree is passed in the suits which has been commenced by the presentation of a plaint. Only in those cases the decree is passed. However, the order It may originate in a suit which is commenced by the presentation of a plaint first, or it may arise from the proceeding which has been commenced by a petition or an application. So decree will be passed only in a suit which has been commenced by the presentation. However, order it can be passed in a suit which has been presented by the presentation of the plaint, the petition or the application, right? In all these cases the order can be passed. Decree, it determines the rights of the parties conclusively with regard to all, जितने भी मैटर्स होंगे या फिर कोई भी एक मैटर, उनकी कंट्रोवर्सी को डिसाइड करना क्या होगा, डिग्री होगा. हाउ एवर एन ऑर्डर इट कैन नॉट, इट मे कर भी सकता है एंड इट मे नॉट, और नहीं भी कर सकता, फाइनली डेटरमाइन सच राइट्स. बट डिग्री के केस में क्या होगा, ये कंक्लूसिवली डेटरमाइन करेगा ही करेगा, राइट. थर्ड डिफरेंस, डिग्री में बी प्रिलिमिनरी और फाइनल, पार्टली प्रिलिमिनरी and partly final, but there cannot be any such order which is preliminary or final, partly preliminary or partly final, right? Except in certain suits where two decree, one preliminary and the one final are passed, there is only one decree. However, in a suit or proceeding there are number of orders which can be passed by a court. Next, every decree is appealable. However, every order is not appealable, but both are subject to what has been provided in the code. Every decree is appealable unless the court is restricted it, or every order is not appealable unless the code is allowing it, right? Next is a second appeal. It may lie to the High Court on certain grounds from the decree which has been passed in the first appeal, right? But there is no such appeal, no such second appeal in the case of the appealable orders, right? So these are the distinction. Do it properly. Next is decree holder. Who is the decree holder and where it has been defined? It has been defined under section 2 clauses 3. It means a person can be any plaintiff, or any third party or any other person in whose favor a decree has been passed, or any order which is capable of being execution. मतलब कि भाई आपको ये काम करना है, इस जो भी आपका मैटर ऑफ कंट्रोवर्सी था उसमें भाई आप इस चीज़ के लिए आप राइटफुल हो, दैट पर्सन विल बी नोन एज द डिक्री होल्डर. ही नीड नॉट नेसेसरली बी द प्लेंटिफ, ठीक है. अ पर्सन हु इज नॉट अ पार्टी टू द सूट मीन्स अ थर्ड पर्सन अपार्ट फ्रॉम प्लेंटिफ एंड डिफेंडेंट in whose favor an order capable of execution has been passed is also a decree holder, right? What are the other person, who are the other person can be a decree holder as per the CPC? Who are those? See, when a decree for specific performance is passed, this is kind of decree which is capable of execution by the plaintiff as well as the defendant. So either of the party, nothing, no, not one, not only the plaintiff is the decree holder or the defendant is the decree holder, either of the party, because this kind of decree is capable of execution by both the parties. So any party can be the decree holder here. Okay. Decree, if a decree is conferring some right to execute the decree on any person, he is a decree holder, right? For example, eviction order has been passed in the rent case, okay, and time has been given to the tenant to vacate the premises. Can we say that the landlord is a decree holder? No, we cannot say that he is the decree holder till the time which has been granted by the court to the tenant to vacate the premises is over and the decree becomes executable. Till then we cannot say that the landlord is the decree holder, right? Next is judgment debtor. Who is the judgment debtor? Section 2 clause 10. Any person against whom a decree has been passed or an order which is capable of execution has been made is a judgment debtor. Okay, and where a decree is passed against a surety, he is a judgment debtor, right? On the other hand, a person who is a party to a suit but no decree has been passed against him, will he be a judgment debtor? Of course not. For a judgment debtor, it needs that the case has been decided against him. Okay, or any order which is capable of execution has been made against the person. Only that person can be known as the judgment debtor. Now, the foreign code, section 2, clause 5, as the name indicates, foreign means something which is not situated in India. That means a court which is outside India and which has not been established or continued by the central government. So we can say the example of these are the courts which are situated in England, Scotland, Ceylon, Burma, Pakistan, and those of privy councils. These are the foreign courts, right? Now we will study what is the foreign judgment. Section 2, clause 6, here it has been defined. Judgment of a foreign court is known as the foreign judgment. And what is the date to determine whether it is a foreign judgment or not? It is the date when the court has pronounced that judgment. Okay, note the date when it is sought to be enforced, when the judgment is sought to be enforced or executed. That will not be the date of the, that will not be the, we cannot say that it is the foreign judgment. If you have to determine technically that this is the foreign judgment, then you have to see when it has been pronounced by the foreign court, right? Why is this so? See, supposingly a judgment which has been passed by a foreign court, at the times of pronouncement, it would not cease to be a foreign judgment. Why this? Why we are determining the date of the judgment of the foreign court? Because if it happens that after the pronouncement of the judgment, the Union of India has taken over that foreign territory, which the foreign territory in which that foreign court was situated, and that foreign judgment has been passed by that court, will that judgment be not will that judgment be not a foreign judgment after Union of India has acquired that territory? Absolutely not. We have to see the date of pronouncement. If after the pronouncement of the judgment the foreign territory has been acquired by the Union of India, that will not cease to be a foreign judgment. That will be a foreign judgment, okay, after the pronouncement of the judgment. And similarly, in the Indian court's case, if an Indian court has decided a case, okay, and after the court has decided the case, a partition has taken place. Okay, so we will not say that this judgment has ceased to be an Indian court judgment after the partition. No, we have to see the date of the judgment, right? Next, legal representative. Who are the legal representative? Section 2, clause 11. Legal representative is not only your legal heir. It includes many other person. Who are those? See, it means a person who in law represents the estate of a deceased person, and includes, क्या include करता है? Any other person who intermeddles, means who interferes with the estate of the deceased, and where a party, the plaintiff or the defendant, is suing or is sued in a representative character. Okay, after the decision of the case, the person on whom the estate devolves on the death of the party so suing or sued, those will be known as the legal representative. Let's do it again. The person who is representing the estate of a deceased person. Very simple. Just in the Hindu families, it happens, right? A son is representing the father, so he is the legal representative. He is representing the estate of his father, so he is the legal representative of him. Okay. And other person who are intermeddling with the estate of the deceased, those are also be the legal representative. Okay, and a party is suing in a representative character or is being sued, means plaintiff has a plaintiff has filed the case in a representative character and the defendant is defending the case in a representative character. In both of the cases, after the death of any of those, any party on whom the estate is devolving is known as the legal representative. If he dies and his estate devolves upon any person, he will be the legal representative of him. If he dies who is being sued, then the person on whom his estate devolves will be the legal representative of him, right? What are the examples of legal representative? Who we have said that any person, he can be the legal representative who is intermeddling with the estate of the deceased. So who are those persons? Executors, administrators, reversioners, Hindu co-partners. Hindu co-partners comes in this first line. Okay, residuary legatees, these are the legal representatives. But a trespasser, can we say that any person who has been trespassed into your property will be the legal representative of yours because he is intermeddling with the estate of yours? No, he will not be, because he is not intermeddling with the intention. His intention is not that of representing the estate of the deceased. Okay, so a trespasser, he cannot be a legal representative. Similarly, a succeeding trustee, official assignee, or a receiver, these are also not the legal representative of the person who has been died. Okay, because these are not representing the estate of the deceased. Who? The trespasser, succeeding trustee, official assignee, and the receiver. Who are the who are the person who intermeddles with the estate of the deceased? Hindu co-partners, residuary legatees, reversioners, administrators, and executors. So students, I hope that you have got all of these definitions. This is all for this lecture. Thank you so much. Bye bye.